Okay, we now begin our second session, and my interest is to research the death penalty, and abolition of death penalty, and some proposal to make any prophecy or prospect about the legal reform in the Republic of Korea. How do you consider the issue is now contended in this, Republic of Korea? And the project is given with some research grants to investigate the comparative view between the United States and South Korea, and also have some complements with international laws or treaty about the specific concern. So the issue of death penalty would be one of hyperboles contained in a debate in the state, national and international arena. As you will see, it would be worst of a capital punishment and had impressed symbolically the political power of state. Would it be legitimate or serve the criminal policy? The question of this kind would well be awakened and thought-provoking, which is not merely for the taste of philosophers, but most practical or realistic in the transition. The death penalty is a term which denotes the execution of life, sentence to death, and one sort of criminal punishment in states or nations. As it is most extreme retribution of state for the criminal offenses, we may alternatively use capital punishment to indicate it. According to Amnesty, 58 countries among 198 ones in total endorse its legitimacy and manages a national system to administer the death penalty. So your first work is to investigate some background information to direct your purview and also shape some focus to through the research operations. So you research, for example, Dahum website, and may collect some second sources about that issue. So let us type a keyword in Korean. Then you will see some information, of course, encyclopedia. And now you will see the use of Wikipedia in to serve many interests of public, and one source to be consulted when you conduct a preliminary investigation. And you will have information about second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of death penalty. It was formulated in the year of 1991 under the initiative leadership of United Nations, and perhaps Korea would explore its membership. In my knowledge, Korea is not a member state, but more importantly in practice, Korea is now classed as one of most formative state to renounce from any execution of death penalty. Legally, we now maintain the death penalty is the kind of institution in the criminal statute. So what actually the ideas of criminal justice system would be purposive of what, for example, deterrence or prevention, or what, education, the kind of many points to be pursued about some explicit what a fair explication about community and others. So what is criminal justice do? What retribution is salient in some cases, which assuages the rest of a rage, kind of anger of public, and it seems to be due justice to be restored against the cruelty of crimes, atrocities, and must be punished. Is the justice of God long held in the mind of humanity, as you see. But how do you find it to go wrong in any fundamental way if we adjudicate wrongfully? On false evidence, for example, what is miscarriage of justice to prejudice permanently against the interest of one human subject? In the kind of many points in consideration would be raised in your basic understanding of criminal law course in this department. And we also would be one great advocacy to pledge with European Union about non-execution. The promise of non-execution have been conformed in a great compromise with the European Union, for example. So basic ethos and tones are very associative with the demand of international community. And the problem about this concern is that often the capital punishment is actually practice involving political nature of crimes. So political persecution and some fundamental deprivation of civil lives would come at forefront to be consulted or interactive about due tense of this challenge. Okay? So how do we persuade ourselves, explain ourselves about fundamentally wrongful justice, which is in some cases scheme and enforced in the interest of sectarian politicians or others, in the kind of dictatorship would often associated to strengthen this tendency about wrongful execution or kind of death penalty. So we would have be disappointed about occasional reporting. And how do you assess the abolition of death penalty in terms of human rights, general standard of human rights? Of course, the state power is very symbolic. So in some sense, it could not be waived or dispensed with international consonance. In some cases, dissonance might be well surface about a final result of a state authority. For example, United States would make a reservation about abolition of death penalty, and also the view of Senate would find some commitment is. It is also a point of consideration that the ICCPR, the International Covenant on Civil and Political Rights, have been signed with a reservation from sources. Senator Vincent has made some a meaningful comment about its legal effect and some views on languages of the covenant. So, in countries which have not abolished the death penalty, sentence of death may be imposed only for the most serious crimes in accordance with the law in force at the time of the commission of the crimes, and not contrary to the provisions of present covenant and to the Convention on the Prevention and Punishment of Crime of Genocide. This penalty can only be carried out pursuant to final judgment rendered by a competent court. Nothing in this article shall be invoked to delay or to prevent the abolition of capital punishment by any state party to the present covenant. And let us take some point from the language of preamble in the United States Constitution. Every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. And United States Declaration about the Geneva Convention relative to protection of civilian persons in time of war, August 12, 1949, I made the following declaration. From that declaration, we will see one part pertaining to our discussion. I'm instructed by my government to sign and blah blah blah. The United States reserves the right to impose this penalty in accordance with the provisions of Article 68, paragraph 2nd, without regard to whether the offenses referred to therein are punishable by death under the law of the occupied territory. And also concerning optional protocols of December 15th, 1989, the optional protocol to ICCPR was adopted in New York on December 6, 1966, and entered into force on July 12, 1991. The United States has not signed either protocol. Oh, sorry. Actually, the United States was not a signatory state of this covenant. And United States Senate report on ratification of international ICCPR, the citation from on this material would be Senate Executive Report 10223 of March 24, 1991. Pursuant to ICCPR Article 6, Paragraph 5, sentence of death shall not be imposed for crimes committed by persons below 18 years of age. In 1996, U.S. Senate ratified ICCPR with various reservations, understandings, declarations, and provisions stating in pertinent part U.S. reserves right, subject to its constitutional constraint, to impose capital punishment on any person. So the next year, the United States signed the ICCPR, but with a scope of reservations, and the gist about this aspect is that the United States viewed the ICCPR, especially Article 6 or other pertinent parts would not mandate abolition of death penalty. So it is viewed in terms of kind of a recommendation or some ideal option in terms of a covenant purpose, but has been less actually ambiguous in phrases and languages, whether to be clear about mandate or others. But in that case, the interpretation should be weighed in the interest of state. That is a basic general principle of international law about presumption of state sovereignty, and actually that is most foundational framework to sustain the current regime of international law. So we generally see the context should be resolved in case of due ambiguities, or then of course it might be controversial. And also I once introduced the dominant practice, and perhaps classed as one of principle to be concerned of international law. So the treaty itself could not be applied in the domestic court, and often the United States and other common law countries would perceive the international treaty should be transformed into domestic law in order that it could be imposed or forced in the domestic proceeding of court. And also the presumption doctrine would would not be applied in case the treaty language is very specific and could be elaborated into the same level of a domestic law. The kind of specifics and details could be delineated through the work of a court judicial justices or juries. Then it could be applied without further clarification or other evidentiary support. And also, in some cases, the treaty could be made with express language or signature that it could be applied directly, immediately, without any transformations and forms of law to be converted into domestic law. And the kind of principle would have some differing point and approach. In the civil law system, perhaps you will see some extent of respect as differs from the common law or practice of common law countries. And we have that approach in our constitution, and international law would be respected. And with respect to abolition of death penalty, however, the constitutional code would conform the UN Declaration of Human Rights as merely suggestive and instructive, and would not be entitled to any normative force in its terms of its enforcement. So the argument raised by counsel in death penalty has been legitimately denied on that basis, and many great propositions about basic philosophy and humanity kind of extensive reach over a classic concern have been found in your materials, and you will see. Sorry to interrupt the class progress. Professor Kim Jong-gu has suddenly intruded my office. Actually, I was engaged to prepare for some translations about the international symposium. So some articles written in English, and my role is translation. Okay, what point we have now? So actually, the death penalty is your topic in final project. Now we explore some other websites. Usually, on our experience, LexisNexis Academic, and I type keyword abolition of death penalty. It allows a scope of materials, which is actually very extensive. So the actually your skills to search through the retrieve the articles and some sifting and winnowing to find any pertinent authority about adequate scope of your search. I consider the point is some cultural aspect, since it is comparative between the United States and Korea. And the second topic raised in third session of this class also have some exposure about the cultural aspect, cultural defense. How do you assess the theory in the use of cultural defense? Perhaps one point to be addressed by Professor Bohanian in the next week symposium. Let us consider the use of acculturation and the development of death penalty.